You're driving home from the range. Your legally owned firearm is secured in your vehicle. Red and blue lights flash behind you. You think you know the rules, but 5 recent court decisions just rewrote the script. What was responsible last year could land you in cuffs today. I'm a criminal defense attorney. I've watched too many law-abiding gun owners walk into my office facing charges for laws they never saw coming. In the next 12 minutes, I'm revealing the 5 assumptions that will now destroy you during a traffic stop, the shocking penalties hiding in the fine print, and the exact phrases that become your shield. Let's begin. Assumption 1: silence equals compliance. The legal pact between gun owners and law enforcement in duty to inform states has been shattered. Imagine this: you are pulled over in Michigan. Valid CPL, firearm in the console. You hand over your license, registration, and insurance, assuming your permit status speaks for itself. 40 seconds pass before you mention the gun. You are now a violator. In a real ruling, a driver handing over his CPL card without immediate verbal disclosure was found guilty. The clock started the moment the officer reached the window. First offense, $500 fine, 6-month permit suspension. Second offense, $1,000 fine, permit revoked. In states like Alaska, Arkansas, Louisiana, Michigan, Nebraska, North Carolina, and Texas, immediate means now. Not after pleasantries. The wrong way. Officer, license and registration. You, hands them over, waits, oh, and I have a CPL. The right way. The instant the officer is at your window, before he speaks, you say calmly and clearly, "Officer, I have a valid concealed carry permit and I am armed. My firearm is located in the center console. My credentials are here on the dash. How would you like me to proceed?" Then stop. Hands visible. You have transferred control and obeyed the new, unforgiving standard. Assumption 2: officer discretion is your friend. Forget the old understanding. A recent expansion of Pennsylvania v. Mims means the moment an officer utters the phrase "officer safety," your choices evaporate. The scene: you've disclosed properly. The officer says, "Step out. I need to secure the weapon for safety." Here, most owners make a fatal error: they debate. That conversation is over. The dialogue that gets you arrested. You, why? I told you where it is. I'm not reaching. Officer, step out now or you'll be charged with obstruction. You, this is ridiculous. I know my rights. You are now in handcuffs. Not for the gun, but for arguing after a lawful safety order. Your only move. State clearly, "For the record, I am complying under protest." My hands will remain visible. Then move slowly, deliberately. You fight this in court with a lawyer, not on asphalt with an agitated officer. Assumption 3: your permit status is private. Multiple states have digitally linked concealed carry databases to license and registration systems. When your plate is run, your permit status flashes on the screen. This isn't convenience, it's a trap. You're in Arkansas. You're nervous, you forget to disclose. The officer already knows. He returns, "Sir, I see you have a permit. Are you armed?" You are now cornered. Say yes, you violated duty to inform. Say no with the gun present, you've lied to an officer. Penalties: up to 90 days in jail, $1,000 fine, 1-year permit suspension. Forgetting is now legally indistinguishable from refusing. The shield: disclosure must be your first utterance, before documents are requested. If you forget, correct it immediately. "Officer, I need to add something critical. I have my permit and a firearm in the vehicle." Assumption 4: within reach is common sense. Fallout from cases like U.S. v. Rahim has warped the definition of accessible. It's no longer about your person. If you could access it during the stop, even with movement, it's within reach. You're in Colorado. Gun is unloaded, cased, in the console. You're outside the vehicle. Officer retrieves it. You can be charged. The console was within reach the moment you were behind the wheel. State laws vary wildly. In Texas, a licensed carrier can have it in the console legally, but an officer can still secure it. In Michigan, without a CPL, it must be unloaded and in the trunk, the console fails. Your script: "Officer, my firearm is stored in the center console, unloaded/loaded. I have not and will not access it." How would you like to proceed? Never argue accessibility. Describe, disclose, and defer. Assumption 5. Volunteering information is always safe. In non-duty to inform states, you think disclosing shows good faith. Sometimes it does. But voluntary disclosure can become a fast pass to waiving your Fourth Amendment rights. Scenario: you're in Idaho. No duty to inform. You offer, "Officer, I have a firearm in the glove box." He says, "Mind if I secure it for the stop?" You say, "Sure." He opens the glove box, finds your gun and an old prescription bottle. Now you're facing additional charges. You consented to a search. The critical distinction: request versus order. Request: "Do you mind if I look?" You can and should say, "I do not consent to any searches." Order: "I am securing the weapon for safety. Step out." You comply, under protest. Clarify on the spot. "Officer, can I see your firearm?" You, "Officer, for clarity, is that a request or an order?" His answer dictates your next move. Protect your rights. Do not offer open-ended consent. The recap: 5 assumptions that will betray you. Silence equals compliance. It is now a costly fallacy. Speak first, immediately. Officer discretion is reliable. The words "officer safety" are a legal tripwire. Comply, then contest. Your permit is your business. Digital linking means they already know. Forgetting is not an excuse. Within reach is obvious. Courts have expanded it. Assume any interior compartment qualifies. Volunteering is protective. It can be the first step to waiving your rights. Know the difference between a request and an order. Your 4 universal phrases. Am I free to leave? Establishes detention status. I invoke my right to remain silent. Stops questioning. I do not consent to any searches. Protects the Fourth Amendment. I want a lawyer. Ends the conversation legally. Practice them. Be calm, be polite, be unshakable. The smartest gun owners aren't the ones who talk their way out of trouble. They're the ones who know, with precision, when to speak and when to stand silent. If this was vital for you to know, share it. Subscribe for more unfiltered legal clarity that puts you back in control. This is education, not personal legal advice. If you're facing charges, get a lawyer immediately. Stay safe. Stay legal. And stay prepared.